outsourcing of government services is a global trend. In South Africa, we call this tendering. Virtually every facet of public life can be contracted out by the state. This can range from the provision of water and sanitation to the management and the running of prisons. This tendering exercise has profound implications for rights contained in the Bill of Rights. I want to consider in this talk the implications particularly for the right to education. First, let us talk about the structure of the South African Constitution. It provides in Section 7 certain obligations imposed on the state: the duty to respect, the duty to protect, the duty to provide, and the duty to fulfill human rights. It has a specific section dealing with the right to education. Particularly in Section 29, the state is under an obligation to provide basic education. Notably, at this point, there is no corresponding obligation on the private sector. So the provision of education can span a range and multitude of provision of resources, from the acquisition of textbooks to the building of schools, to the employment of teachers, and all other resources that are required for the provision of the right to education. So how has the Constitutional Court managed the otherwise tense relationship between the public and the private in relation to the provision of education? We should start with a case known as Jerome Wooster. The basic facts in that case were that a private party, which was a trust, was an owner of private land. On that land, the government leased the property in order to run a school. The government, and should I say not for the first time, defaulted on its responsibilities to pay rental. The private party wanted to exercise its rights as an owner of the land, particularly by evicting the state for non-payment of rentals that were due. When the matter came before the Constitutional Court, an innovative approach was developed. Whilst ordinarily a private party would have been entitled to exercise its rights as a landowner, including the right to evict the school, the Constitutional Court felt allowing the private party to evict the state would have negative implications for the right to education. So although there is no textual foundation for the duty, the Constitutional Court nevertheless held that the private party was not entitled to simply evict the school, even though the government had failed to comply with its obligations under the tenancy agreement. In doing so, the Constitutional Court used the doctrine of reasonableness. Now that doctrine, according to the court, has two implications which are immediately important. The first, at a substantive level, is that a private player may not interfere with existing access to rights, including the right to education, unless there is adequate justification. And the question whether there is justification is purely factual. And the second implication is at a procedural level. So the private sector should show that whatever steps that it wishes to take, if they will interfere with existing rights, those steps should be reasonable. So that concept of reasonableness has been applied to impose sometimes positive obligations, not simply negative obligations. And we have seen that in many cases dealing with the provision of housing. So a poor person who is unable to pay for their rental may not be evicted from their property without an inquiry into the existence of alternative accommodation, unless the party purporting to evict them can demonstrate that it has taken reasonable steps prior to the eviction. These instances we have spoken about, one in the context of education and the other in the context of housing, have recently been debated in another case called On Pay, which is an important case recently decided by the Constitutional Court in relation to the provision of social security. Social security in this country includes the payment by the state of old age grants, of disability grants, and children's grants. So what happened in the all pay case is that the government outsourced, a wide-scale outsourcing process, the provision of pensions by a private party. A successful tenderer, although they were appointed unlawfully, nevertheless secured the contract. One of the unsuccessful bidders sued for the cancellation of the contract on the grounds that it had been unlawfully awarded. When the matter came before the Constitutional Court, there was a distinct risk that a rerun of the process might interfere with the provision of basic services that are also provided for in the Constitution, particularly the provision of social welfare or social security. Now, in order to deal with this issue, the Constitutional Court has developed the imposition of rights beyond the private sector. Now, it is no longer a question whether or not there has been an interference with an existing right, but the Constitutional Court also imposed a duty to continue the provision of grants, notwithstanding the fact that it was a private player rather than a public player that was at issue. But there is an important aspect of the judgment. In order for the court to reach the conclusion which it did, namely that there was a duty imposed on a private player to discharge public responsibilities, it had to conclude that on the facts, by assuming the obligation to provide pensions, the private player had become an organ of state for the purposes of the Constitution. So we see from this conclusion that although the court is willing to impose public law obligations on a private player, it is not willing to do so unless it fundamentally alters the characterization of the private player and understands it essentially as a public law player. So we can see, I think, that in South Africa, constitutional law has caught up with commerce. Commerce, as we know, no longer draws distinctions between the public and the private. And similarly, our law is increasingly no longer drawing distinctions between the public and the private. But nevertheless, it is still important to note that before the lines are blurred, the Constitutional Court sees it as part of its responsibility that there should be a fundamental alteration of the understanding of the relationship between the public and the private law spheres. Whilst this is an exciting development, we yet wait to see whether or not it will be followed in subsequent judgments. And it is also worth noting that perhaps it may not apply in other jurisdictions. Our Constitution provides for a broad remedial discretion on courts. Courts are required to find remedies which are just and equitable. And that is a flexible standard that potentially enables our judges to adopt expansive mechanisms and expansive remedies when they deal with violations of constitutional rights. So that doctrine of justice and equity has been the instrument by which our judges have sought to expand responsibilities beyond the public sphere into the private sphere. Thank you.